Thanks very much for viewing this video. I'm patent attorney Steve Keefe. This is Decision Point, a series of brief videos to inform IP decision making by innovative enterprises. Today's topic is stopping third parties from stealing your invention. A common question our clients often have is, I need to talk to third parties about my invention, but how do I keep my invention from getting stolen? The key point in time with this inquiry, this question, is public disclosure. In addition to talking to third parties such as prospective investors, prospective parties to form a joint venture with, any other third parties that might be interested in bringing an invention to the marketplace. In addition to that type of disclosure, third-party disclosure can include trade shows. Trade shows are very dangerous for patent rights. Internet posting, selling, offering to sell, writing an article, really any public disclosure would fall into a similar situation as needing to talk to third parties about commercializing your invention. The best practice, the best action to take prior to any type of public disclosure is to file a full and complete non-provisional utility patent application. Have that on file with the USPTO at least one day, hopefully further in advance than disclosing your invention publicly in any of those examples we just covered. But really, as long as you have it in the day before, even though that's cutting it close, that is the best practice. If filing a full and complete non-provisional utility patent application isn't possible, whether it be based on lacking the financial resources at the time, not having enough time to prepare and file that type of complete application, the next best option in most circumstances is to file a provisional patent application, which is not as complete typically as a non-provisional. It still needs further development. It still will need tweaking. It's not as good as the non-provisional to have that on file prior to public disclosure, but it's often your next best option. If it's not possible to have either a non-provisional patent application or a provisional patent application on file prior to public disclosure, another option, not as optimal, is to have a non-disclosure agreement in place with all of the other parties, whether it be one or more, that you are going to publicly disclose your invention to. Have that in place prior to the disclosure. The NDA option is often not bulletproof. It comes with a number of pitfalls that aren't the case in filing a non-provisional patent application or even a provisional patent application. Other parties can violate the NDA. You may only be left with a cause of action and contract against that party, and yet your invention may still be disclosed to the world and act as destroying prior art to your invention. So even though NDAs are an option, they may be a low-cost option that may seem attractive, understand that they often come with pitfalls. They are not bulletproof. Just as a quick note, the options can be used with each other. For example, you can file a patent application and also execute an NDA, which provides additional protection. But in summary, of the three individual options, the non-provisional utility patent application, having that on file with the USPTO prior to disclosing your invention publicly, whether it be to a third party or any of the other examples that were discussed earlier, that is your best option, your best practice for preventing your invention from being stolen by third parties. Thanks very much for watching this video. This was the Decision Point edition on protecting your invention from being stolen by third parties. Again, this is patent attorney Steve Keefe. Please feel free to reach out to my firm at any time. Thanks again.